Hello, everyone. I think maybe we'll get started. Thank you so much for being here on time, and we want to make sure we can get through and have as much time as possible to answer questions and answers at the end. So, hello, everyone. My name is Christy Fugio. I'm the executive director and a co-founder of Synergy for Justice. I'm delighted to welcome you to the online launch event for the Syria Supplement to the second edition of the International Protocol on the Documentation and Investigation of Sexual Violence in Conflict. Before we dive in, I'd like to start with a few notes and requests to ensure that everyone is able to take good advantage of the learning opportunities that we have today. First of all, the webinar is bilingual. We have both English and Arabic speakers, and we hope to optimize the experience for everyone. So please take a look at the bottom of your screen for the globe icon, where you can choose either English or Arabic. Secondly, we are recording the webinar so that people who are unable to join today can access it later. We'll post on social media when the recording is available, and at that time, please feel free to share with friends and colleagues who might be interested. You may have noticed that you're on mute, but later during the Q&A session, if you'd like to ask a question, please raise your hand and then we'll ask permission to unmute you. It's a two-step process, then you have to accept that. Alternatively, you can type a question into the Q&A box. Whether you're asking verbally or using the Q&A box, please do share your name and organizational affiliation so that we know who you are and we can respond appropriately. We'll do our best to answer all the questions and we'll just see how it goes. And then finally, if you look in the chat box, you'll see links to the Syria Supplement that we'll be talking about today. So you can access it now or you can access it later. It is available as an executive summary and also in English and in Arabic. Okay, thank you. So then let's get started. So with a brief introduction, Synergy for Justice is a global multidisciplinary justice organization. We advance justice and accountability through locally driven and survivor-centered approaches. We're grateful to our Syrian partners, Lawyers and Doctors for Human Rights, and the Amal Healing and Advocacy Center for their valuable contributions to the report through their own expertise, as well as through the facilitation and integration of survivor voices and perspectives into this resource. We're grateful to the technical experts who brought decades of expertise to the development of the Syria Supplement. Before I explain a little bit more about the purpose and the genesis of the Syria Supplement, I'd like to introduce our panelists to you. First, I must note with regret that one of our co-authors and a co-founder of Synergy for Justice, Dr. Ingrid Elliott, is unable to join. Ingrid is a criminal investigator and a prosecutor with over 20 years of experience, including investigating and prosecuting international crimes with a focus, on sexual violence. We are in excellent hands, though, with the rest of the panel, which includes our other co-authors, as well as our invaluable Syrian expert contributors. Stephanie Barber, one of our co-authors, is an international criminal investigator, analyst, sexual violence expert, and legal advisor with over 16 years of experience in domestic, hybrid, and international criminal justice initiatives. Steph will be facilitating the panel today. We also have Jomana Saif, another one of our co-authors who's a Syrian lawyer who's been at the forefront of universal jurisdiction efforts. She's a legal advisor at ECCHR, where she focuses on Syria and sexual and gender-based violence, and she's also a non-resident senior fellow with the Atlantic Council's Strategic Litigation Project. Next, we have Siba Atki, an activist and survivor of detention in Syria. She was a value contributor as part of our focus groups. Finally, last but certainly not least, we have Dr. Mohammed Al-Sharif, who's working in Northwest Syria and is a veteran documenter at LDHR, where he provides quality control and supervision of LDHR's forensic medical evaluations of sexual violence and torture. Dr. Mohammed is also part of the research team of a published study on the long-term physical and psychological symptoms in Syrian men subjected to detention, conflict-related sexual violence, and torture. Okay, so before we turn it over to the panel, let me take a few minutes to introduce the IP2 supplement for Syria and how it was developed. The International Protocol on Documentation and Investigation of Conflict-Related Sexual Violence was developed in its first iteration in 2013-2014 as part of the UK's PSVI, that's the Preventing Sexual Violence and Conflict Initiatives work. In 2017, an updated and improved document, this time better integrating survivor-centered approaches, was published and became known as the IP2. Building on the IP2, efforts began to meet the specificities and realities of different situations on the ground. Four country supplements to the IP2 were published, covering Iraq, Myanmar, Sri Lanka, and Central African Republic. Ingrid and Stephanie, two of our co-authors of the Syria Supplement, were authors and reviewers of the Iraq and CAR supplements. Now, excuse me, I don't remember specifically whose idea it was or who was the bigger driving force, but I definitely remember a Zoom call back in 2020 or 2021 with Ingrid and Steph, where the idea of Synergy publishing a Syria supplement was first floated. After more than a decade of CARSV response in Syria, it was clear that a Syria supplement could be invaluable. There had been 12 years of forging new pathways to accountability. Syrians have been driving so much progress in universal jurisdiction, but we knew there was a lot of room for improvement in terms of working with survivors of sexual violence. We also had 12 years on which we could base renewed discussions about what we could do next, how we could do it better, and how we could really ensure that survivors were driving the accountability agenda. There were also 12 years of insights and experiences to share with other contexts. So this supplement is different. Focusing on survivor-centered documentation and investigation in Syria, it also has explored what has worked and what needs improvement. It adds new content that was not in the initial IP2 or in the other supplements. We have new chapters on persons with disabilities and on survivors with diverse sexual orientation and gender identities. We've also integrated the MORAD code throughout, often adding some Syria-specific implementation guidance along with it. And finally, you'll also see an annex based on the German Code of Crimes Against International Law elements of crimes. Most importantly, the Syria supplement embraces and showcases Syrian expertise and experience. We conducted and have included our original research to capture Syrian voices and insights in the following ways. We conducted focus groups with Syrian survivors, first responders, lawyers, judges, and women activists. We also conducted a survey with over 200 Syrian first responders who are working on CARSV. Overall, more than 240 Syrian voices and perspectives are distilled in the Syria supplement. In addition, the supplement contains some of the findings from Synergy's and LDHR's work with the University of Galway on male sexual violence in the Syrian context. We're also delighted to report that some of that research has also been published in the Lancet Journal. Hopefully my colleagues have placed the link to that article in the chat or will do so shortly so that you can also access that information. Now, without further ado, I'd like to turn the floor over to Stephanie Barber, one of our co-authors and a director of Synergy for Justice, to moderate the panel. Thanks, Steph.
Thank you very much, Christy, and I'd like to extend my own warm welcome to the panel and all the audience members today. It's a pleasure to see so many familiar names, if not faces, in this format, and thank you for being with us. I hope you have all had a chance, if not before today's webinar, now to click on the link in the chat that shows both the English and Arabic editions of the Syria supplement, but I have to wave it at you in the image here and also allow you just to see how thick it is, and to thank Christy for not pushing back during those many subsequent Zoom calls when Jumana, Ingrid, and I asked for more pages, because there was indeed so much to include in the supplement, and we're really proud to say that we didn't forego any topic or leave any stone unturned, and we hope that it really is a reflection of all of the rich insight that was contributed by survivors, by activists and first responders throughout the long processes that we had to gather the inputs for this supplement. So without further ado, I will take you to our outstanding panel for today. And I would like to begin with Siba Atki. Ms. Siba, we're so grateful to you for participating today and also for the insights that you contributed during the Survivor Focal Group for the supplement. As an activist, documenter, and survivor, can you please share with us your perspective on the value of this supplement and some of the most important advice and guidance that survivors contributed to it during the Survivor Focal Group?
سعيدة أوقاتكم. شكرا كثير لهي
Thank
الدعوة.
you indeed for inviting me. First of all, I would like to thank you to speak on behalf of the survivors who have gone through detention, to be the voice of every dark cell that they have gone through. And I also like to thank you to include the voices of survivors in this supplement. In the preparation of this book, we participated in several points. The first point of the survivors who talked about was the stigma. Unfortunately, the first point, when a female detainee is released, she faces the stigma in the society. This society forgets about all the psychological, physical, or sexual violence she was under, and they looked or stigmatized her in society. This stigma affects her life. First of all, she might be persecuted by her husband, or isolated by the family, or even threatened to be killed by the surrounding environment. Her children as well will be affected by this detention, because they will be isolated based on the detention of their mother, which will impact her, stigmatize her, and she will have self-blame. This, of course, will make her detach from society, and sometimes it will lead, in extreme cases, to committing suicide. I would like to say here that the stigma that men have sometimes is equal to the stigma women has in some cases. The second point that I want to focus on is that when a woman or a survivor comes out of detention, we have a lot of organizations that want to document their case. But the first trap the survivor falls into is going to media outlets. Media outlets are not legal entities to document the case. So he will become a trap for a scoop on the media, and his face, his information will be dealt in public, so they will not have control over their information or their data, and this leads to fear and anxiety how this information can be received by the Syrian authorities. Now, how did we do this in the preparation of this work? First of all, we had a problem in documentation. Sometimes the documenter would be speaking a language other than Arabic, so we need to have an interpreter during the session. So this makes the survivor nervous, because there is another person listening to the story. The second point is that the documentation is not coming from the safe space that the survivor wants to have. The third point is that the documenter usually do not follow up on the cases of the survivor after documentation. So they only take the story and they do not update the documentation with any developments that happen with the survivor. Another point is that the documenters are not survivors themselves, because when we have a survivor doing the documentation, sometimes they can avoid certain escalation points, or they can know how to deal or to avoid certain questions and ask questions in an appropriate way. Another problem was the repeated documentation of the same case, the same story. This sometimes re-traumatize the person, because he's recalling the story or she is recalling the story several times, and this might also make some gaps in the story when it is repeated several times in terms of dates or certain events. Now, we as survivors, or in the focus groups that we did, we all demanded to put all the perpetrators to account. And at the end, we had some recommendations for providing psychosocial support and sometimes vocational training for some of the survivors. And of course, the survivors need to know how their data is being preserved, maintained, and protected. And what happens to the document since the point or the moment they document their case until it reaches the court. So the engagement of survivors is very important because we want to see justice served for our cases and to restore our rights. One of the points that there was agreement on that when the survivor is living in a host country, they need to have some kind of immunity because they shared their stories and the story of their detention, and this is putting the survivors at risk in the countries they are living in. These are the recommendations that we came up from these focus groups. Thank you very much indeed, and this is very helpful. This work can be very useful for us. Thank you indeed.
Thank you very much, Ms. Siba, not only for keeping to the time, but also for reminding us of the importance of humanizing the documentation process, both to ensure that survivors are not further harmed during documentation, but also not to undermine the integrity of their evidence that they may provide during those processes. Thank you. It's my pleasure now to turn to my colleague, Dr. Mohammed Al-Sharif, a longtime documenter of torture and sexual violence through forensic medical evaluations conducted with LDHR, as Christy mentioned, and with whom I have had the honor to work with on a recent UK-funded research project on the long-term impacts of male sexual violence in Syria, the results of which, first results of which have just been published in eClinical Medicine, a Lancet journal, which Christy will say more about at the end of today's webinar. Dr. Mohammed, given your experience of working closely with men who have been subjected to conflict-related sexual violence, could you please share some of LDHR's lessons learned on supporting Syrian men and boys?
شكرا ستيفاني شكرا
Thank you, Stephanie. Thank you, Siba, for your contribution. Thanks, Christy, for the introduction. I would like to thank all the attendees and participants. I am a documenter with LDHR. In my documentation work, I work with survivors of detention. As a doctor, I work in a human rights organization as well. As Stephanie mentioned, during the past period, we worked on research on sexual violence against male Syrian detainees, most of which was integrated in the 17th chapter of the IP2, which Stephanie referred to, which contains some of the ideas around the myths and stereotypes related to this type of violence, in addition to addressing the scope and forms of this sort of violence, in addition to some recommendations and considerations to be taken into consideration by those working with male survivors, be it relief workers or documenters. We worked in LDHR recently with Synergy and the Ireland National University in Galway on this research project around sexual violence against males in conflict areas in Syria. It contained interviews with 106 male survivors who have already been documented by LDHR, and it offered an opportunity for a further in-depth understanding for this kind of violence, what are the motives and what are the impact with time of this sexual violence against male survivors, in addition to the barriers that prevented survivors from accessing those services after their release. To start with, we all know that talking about sexual violence against men is not something ordinary in the Syrian society, and there are many myths and stereotypes which the protocol sheds light on, and we all come across in our work with survivors, and which are attributed to social norms and the social culture, and it mainly hinges around the lack of recognition of the fact that men can too be victims of sexual violence, in addition to the confusion and lack of understanding of the motives of sexual violence. And these misconceptions often reflect on the experiences of male survivors who become very reluctant in sharing their sexual violence incidents. However, when offered a safe space, they were able to disclose the various forms of sexual violence they were subjected to, whether through the forensic medicine or forensic medical evaluations or through our interviews in the research. And we found that around 10% of the survivors, male survivors, were subject to one form of, at least one form of rape, and more than 75% were threatened with sexual violence. And this is quite striking. And what is worrying is the cruel nature of sexual violence reported in the Syrian context, including electrocution of genitalia, burning, and castration and mutilation of genital organs, etc. As Christy mentioned, this review included an overview of the long-term impact of this violence between the time when they were in detention to the impact immediately after the release, and then also when they were interviewed in the forensic medical evaluations, and finally at the time of the study or the research. And our findings were that all the male survivors suffered pain at the time of being subjected to this violence. Many of them, and most of them, had wounds, bleeding, bruises, and sometimes motor injuries, or even a loss of consciousness, in addition, of course, to the psychological impact, including sadness, despair, and extreme fear and anxiety. And with time, they continued to suffer pain, anxiety, and sadness, and also lack or loss of self-esteem and intrusive memories, among others. There are also some resilience factors, mainly faith and supportive families. And one of the findings in this context was that around 30% of survivors said they were relieved because they were able to share their stories in their own words. And here comes what Siba just pointed out in terms of documentation, which is the main work of LDHR, allowing survivors a safe space to share their experiences. I would like to actually quote one of the participants who explained this, saying that, I quote, "My story was like a rock that is pushing on my chest. And when I told it now, I feel I've been relieved from that rock." And I would like to point out also that around 3% of the survivors who have been interviewed referred to services as or support services as part of their support factors, but that is attributed to the fact that 75% of those interviewed were not aware of the presence of those services, and many of them feel, 58% feel embarrassed to seek help, and many of them as well cannot afford those services, and many of them also, or 41%, do not trust that those services would be helpful. So at the end, I would like to say that we need to be aware that opening up to recognizing this form of violence is one of the most important steps towards documenting this sort of sexual violence related to conflict, and we should avoid any preconceptions for example, assuming that men are only witnesses of sexual violence against women, but understanding that they can themselves be victims of sexual violence. That's why all those working with male survivors must read and understand the forms of sexual violence, because it would help documenters to understand the words that men and boys might use in reference to this kind of violence, and for documenters to avoid reinforcing the stigma um, or shame it unintentionally. And they must also recognize completely all the sensitivities related to sharing and talking about all forms of sexual violence. And we have to understand that to gain the confidence of survivors, we need time, and sometimes survivors would not share much on the first meeting. Let me conclude by another quote by a male survivor who said, quote, "While others believe that releasing a detainee is an end to their suffering, in actuality, it could only be the beginning." Thank you so much. Thank you, Stephanie, and all the panelists and participants.
Thank you, Dr. Mohammed. So valuable, the view you have given us on this very important work, looking at the long-term impacts and also the barriers that men and boys are facing, not only when they come to access services, but when they seek justice and accountability efforts, and how important it is that they are met with service providers and responders who understand the signs, the symptoms, and the issues that the men might be facing in this work. And of course, many of those insights were uncovered during the research project that you mentioned and have been embedded already within Chapter 17 of the supplement. So I do invite users of the supplement to delve into it and find the research data underpinning those points. I am delighted now to come to Jumana Saif, my deeply esteemed co-author of the supplement. Syrians have been at the forefront of accountability efforts and really have been some of the key agents of innovation and progress in the pursuit of legal accountability, particularly in the universal jurisdiction space. And Jumana, as the lead author on chapters 3 and 4 of the supplement that deal with accountability pathways and individual criminal responsibility, you prepared some very important insights into domestic and international accountability and collations of Syrian law. Could you please highlight some of the critical aspects of these chapters for us, including some of the issues encountered in Syrian law?
شكرا جزيلا ستيفاني، شكرا دكتور محمد وصبا وكريستي، وشكرا لجميع الحضور. بدي ركز ب
Thank you, Stephanie. Thank you all, and thank you for this invitation. What I want to focus on in my word here about some of the points that were covered in the third and fourth chapters of the supplement. Before Stephanie talks about the venues available at the international level, how important they are, and how important it is to have trials outside Syria, I thought that it is also important to shed light on the Syrian judicial system to see what are the possibilities of justice that can be sought in Syria, as based on the research that we have conducted and the analysis that we made in this supplement. Here we need to, if we want to talk about the available points under uh, the universal jurisdiction, as Stephanie said, that was one of the points of the work of the civil society organizations, Syrian and international ones, as well as the European Center for Constitutional and Human Rights. So this is the center that I work in. This support, and by the support of a lot of survivors, we were able to get recognition of the sexual and gender-based violence as crimes against humanity in the Copland's trials. If I want to have an overview of the Syrian judicial system, we need to highlight that Syria is divided a de facto division, and we have different zones of control and influence. One under the control of the regime, and the three other zones outside the control of the regime. We have the autonomous administration in the northeast of Syria, and then we have the opposition controlled areas and areas that are controlled by Hayat Tahrir al-Sham, HTS. All of these areas, in the analysis, we found that there is a lack of stability or there is lack of independence in all of the judicial systems that are used there, and a lack of redress or ability to seek justice in those venues, unless there is a complete reform of the judicial system uh, in all of its aspects. Unless that is done, there will be no venues for any justice or redress inside Syria. Some of the points that I want to focus on: the obstacles that are facing justice for survivors in the different regions or zones of influence and control that I mentioned. We said that in regime-held areas, there is high level of corruption within the justice system. There is lack of independence of the judiciary, and there is lack of the protections, checks and balances, or the protections guaranteed by the constitution or by the law. And there is collusion between the police. There is, immunity that is given to personnel of the intelligence and security forces and the police departments, and there are laws that are inappropriate to deal with the crimes that are related to the conflict. These are some of the problems of the judicial system, in addition to the lack of experience in terms of addressing sexual and gender-based violence that is related to conflicts, or having also lack of experiences in forensic medicine or doctors who are experienced in this field. So we see that these points are not missing only after 2011, but actually all of these points that I mentioned were already problems in the judicial system even before 2011. In terms of the opposition-held areas, the judiciary is controlled by the de facto authorities, whether we're talking about Islamist groups or armed groups. We have also Sharia courts and the absence of mechanisms in these areas. In the autonomous administration area, there is lack of trust in the judiciary because the PKK is the Kurdish Labor Party is controlling everything, and there is a system of the system of committees in the criminal cases there. I'm trying to be brief in these obstacles. Of course, all of these are mentioned in detail in the supplement. If we want to expand a little bit about the judicial system in Syria, especially if we, with the short time that I have, we want to focus on the regime-held areas judicial system. We can see that we have three levels there. However, there are extraordinary courts, and these are the main tool that is used by the regime to control or confront opposition. So we have the counterterrorism court, one of the extraordinary courts that was established in 2012, and it applies broad definition of terrorism to punish a lot of the peaceful activities that are based on the political opinion, etc. So this is used a lot by the regime. Some of the judicial tools are used as tools to crush on the opposition, and of course they are dealing with the even with activists that who are only providing medical assistance to people, and they deal with them as terrorists, and they extract confessions from them under torture. This is very repeated and very frequent based on the meetings and the interviews that we have made as we said that 240 individual interviews and focus groups we conducted for this supplement. In addition to that, we have the field court, and of course these courts issued hundreds of capital punishment rulings without any aspects of the fair trial. So they became a crushing tool that is used by the regime as well. This court recently, on the 3rd of September 2023, after all of these practices and the death penalties that were issued by the Syrian regime and the Assad regime, this formative change that the regime made, this was a preemptive step made by the regime in order to respond to the case that is filed by Canada and the Netherlands in the International Court of Justice. So we don't have, unfortunately, in the judicial system, we don't have any redress venues, or sorry, non-judicial venues for redress in Syria. We don't have such venues. And in the supplement, we have mentioned a number of examples. And here we talked, for example, about the CEDAW committee and their anxiety or their concern that there is no strategy to protect women's rights, and their deep concerns about women and girls from the impacts of violence that is taking place in Syria and not taking any measure by the Syrian authorities in this regard. And I also mentioned the Universal Periodic Review, UPR, which says that Syria reported several times that they have separate entities for investigation of any violations or the widespread violations of the human rights and against women that is taking place in Syria, that there is an independent national authority in 2011, or commission actually in 2011, that was established in addition to the National Reconciliation Committee. They are collecting evidence, etc. This committee and the Ministry of Reconciliation and the Commission of Human Rights, they have very limited credibility, or we can say zero credibility in their work due to the corruption that we have. For example, the no application of is submitted to those entities is accepted without paying bribes. So, from the review of the, or after the reviewing the judicial system, if we want to look at the legal framework and the practices in Syria, I believe after taking a deep dive in the Syrian laws and analyzing these laws, I believe it is very difficult, even for the legal practitioners, law practitioners, to understand the legal framework or how the law is applied. By the way, there is no law. For example, in the penal code, or other than the penal code, there is or sorry, we don't have an updated version of the penal code online, and I believe nobody has such a copy because there were amendments that are periodically happening, although they are formative or just a protocol changes. However, they are not added to the penal code or an updated version online. This is part of the blackout policy that is followed by the Syrian authority or the Syrian regime. I have very quick comments on the Syrian laws and the practices. The Syrian law does not criminalize international crimes such as crimes against the humanity, war crimes, and genocide. There are no provisions in the domestic law that criminalize these laws. The laws of sexual violence in the Syrian law are different from those in the international law or the ones that is mentioned in the IP2. The Syrian law is discriminatory in a very stark way. So many crimes do not apply to all perpetrators equally, if the perpetrator is male or female. Some crimes are not criminalized when they are applied or perpetrated against women based on social or societal preferences. So this led to not criminalizing some crimes whose perpetrators are women and the victims are men. The Syrian law gave almost a complete immunity for the security personnel through the immunity decrees and the decrees of pardon and amnesty that were issued by the Syrian authority. In addition to there are defenses that are provided that allow to give and mitigated rulings. Also, the discrimination against women in the law is also very stark. And based on the penal code, the Syrian penal code, the defenses that are provided or that are allowed in the Syrian law, they are not in line with the defenses that can be accepted or admitted by the international law. And there are some justifications for some crimes against women, including rape. So, for example, the punishment can, or some of the problems here, for example, allowing the perpetrator to marry off the victim, and they will be exonerated from the crime. Or other crimes by law, those crimes will be either forgiven or that the punishment will be in the minimum degree. There is also weakness and lack of clarity about the aspects of or the pillars of the sexual violence because of the use of broad language and indefinite language, using some words like moral crimes or other expressions that are not well defined. So there is no provisions about violence, sexual violence against women, and so, for example, the crime of rape says that, or in the Syrian law, it says that it is the sexual intercourse with a person other than the spouse. So the Syrian law does not recognize the marital rape. And also, there are laws that criminalize homosexuality, and they were not those crimes were exempted or excluded from all the decrees of pardon that were issued. And in addition to um, uh, mentioning in law that security personnel cannot be referred to the court or to have any trials against them without the approval of their superiors. And in addition to not talking about any gender-based crimes. And because of the collusion of the judicial system in Syria with the crimes that are perpetrated, I reiterate the importance of the international authorities, international countries to think of trying those crimes that were perpetrated in Syria in order to serve justice. And also we need to think of compensations that can be provided for the victims, as well as other ways of redressing the victims. Thank you.
Thank you so much, Jumana. I think your remarks have not only put such a stark reminder of why there is no viable recourse to justice in any part of Syria, now or in the recent past, but also why the job of being a legal activist working on Syria can be so incredibly difficult to decipher the complex tangles of legislation, presidential decrees, amendments that make up the legal framework. And you have really done Trojan work for this supplement in helping to piece together as comprehensive as possible a picture of the legal framework and when and where it applies. And I really commend chapter 4 of the supplement, where all of that material can be found, to anyone who is trying to research Syrian law, both for issues of legal accountability, such as looking for jurisdictional bases or answers to why there is impunity for certain crimes in Syria, but also for things like mounting defenses to asylum claims and so forth, so that it can really be shown what the situation is inside Syria over the last 12 years and still today. Thank you. So now it falls to me to give you some final thoughts from the panel before we move into the Q&A with the audience. And I will talk about some of the progress, trends, and outstanding gaps that we face in efforts to advance accountability for conflict and atrocity-related sexual violence through criminal proceedings. And I'll also mention some of the tools and resources that can be found inside the supplement that the community of practitioners may benefit from using. But before I do that, I wanted to just say a word on how the Q&A will work so that you may all prepare yourselves. You are very welcome when we begin the Q&A to put your hand up and ask for the floor, and I will collect up to 3 interventions at a time and put them to the panel. If you're feeling camera shy today or you're on the move, not to worry, because you can also type any question or comment into the Q&A in English or Arabic, and we will take those in a second round. If we have time for third and fourth rounds of questions, we will do so. The panel are also prepared to give us all a final word on what they view as the most valuable part of the supplement for moving the work forward. However, we also agreed to forgo those insights if the Q&A is very lively. So I encourage all of you to be thinking of what you would like to ask, and if you prefer to send it in the Q&A rather than during the putting up your hand to be called on, please feel free to do so. So I think it's more than clear from the remarks from my co-panelists that a huge amount of work has been done to date to try to advance the voices of survivors in efforts to seek accountability in Syria. And it has led to really creative and innovative approaches in criminal accountability that have aimed to address this lack of credible domestic justice in Syria, and equally the lack of an international or hybrid tribunal that would be capable of exercising jurisdiction. So I wanted today to talk about some of the key trends that we see, particularly in extraterritorial and universal jurisdiction proceedings, and also note some of the key milestones that have emerged out of these trends. So first of all, we see more and more the use of structural investigations and joint investigation teams that have been facilitated through the EU's genocide networks and the Eurojust mechanisms, combined with a focus on tracking of perpetrators in Syria who have entered Europe and other states. Several states have made some of these investigations into both regime and Islamic State crimes public, including Canada, France, and Germany. And you can find more details on the use of those structural investigations and JITs, as they are called, in Chapter 3 through specific charts, and in particular box 7. We also see a very strong trend, as in other countries, of NGOs filing complaints where the law permits, and complaints filed by family members of disappeared persons seeking investigations based on the passive nationality of the victims. So cases in which there is dual nationality that might allow the jurisdiction of a third state to be used. We have also seen, again, as in other states, the triggering of jurisdiction through corporate criminal accountability. And I'll return later to talk about one of the cases that promises to be interesting this year in that regard. And of course, we've also seen a very strong pattern emerge of the prosecution of foreign terrorist fighters back in their country of origins, notably including Germany, where prosecutors have also actively pursued women who were married to foreign terrorist fighters on crimes against humanity, war crimes, trafficking, and other charges related to the sexual enslavement of Yazidi women and children, and have even gone so far as to extradite a non-German citizen, Taha al-Jumaili, to face trial. And this is referred to in more detail in Chapter 3 of the supplement in box 5, in a table that lists arrested suspected perpetrators of ICHL violations related to sexual violence and enslavement in Syria. And here I would like to note, for anyone joining us from Iraq, I think I see some names, that of course Taha al-Jumaili was an Iraqi citizen, and his crimes were committed in Fallujah after the victims were transferred first from Iraq into Syria and then back to Iraq. And in that regard, it is very important to note that there is already an IP2 supplement for Iraq, as Christy mentioned earlier, and it can be found on the website of the Institute for International Criminal Investigations and remains a very valuable resource and companion to the original IP2 itself. So now coming to some of the milestones in relation to proceedings dealing with conflict and atrocity-related sexual violence. First of all, we've definitely seen over the years a slow and gradual increase in both the prosecution and conviction of defendants on explicit charges of conflict and atrocity-related sexual violence, most notably in the case of Anwar R, or the Koblenz or Al-Khatib case, as it's more commonly known, and in the case of Sarah O, who, although a minor at the time of her offenses, was convicted as an accomplice to rapes perpetrated by her IS husband against Yazidi slaves enslaved in her household. There are other such cases coming down the pipeline, such as, for example, the case of Ala M, whom many of you with us today have been involved in. We also see a very strong trend of cases against suspected IS members who are accused of holding slaves, including charges such as enslavement and trafficking, which may eventually allow evidence of sexual violence to emerge. And several of those cases, quite importantly, have also charged genocide in relation to the accused slave-owning cases such as Taha Al-J, Yalda A, and Nadine K, all in Germany. A second milestone is we can also observe a really notable trend of participation of survivors as witnesses, as well as co-plaintiffs or accessory prosecutors, as they would be known in Germany, in cases such as Anwar Raslan and Iyad Al-Gharib, in the Al-Khatib trial, and in numerous IS-related proceedings, such as Taha Al-J and the companion case in a parallel prosecution of his wife, Jennifer W. The testimony of these survivors has in all those cases been critical to the convictions for sexual crimes. And in the case of Raslan, it was actually the victims themselves who filed the motion as accessory prosecutors to requalify the charges. And though that issue and that specific example is explored in more detail in Chapter 3 and through Box 5 in Chapter 9, which I invite you to examine. The third milestone is a broader evidentiary contribution to successful cases that we see through the admission of documentary and other battlefield evidence that has been gathered by brave Syrians inside the country. And notable in that regard is, of course, the work of CIJA through its large document collection of both regime and IS documents collected inside the country, and also the Caesar files, which have been critical and will remain critical in a number of ongoing cases. So now I wanted to turn to 5 of the ongoing processes to watch in 2024. I chose this because it would be actually too difficult to look at all of the achievements and milestones that went in the past, because this is a rolling stone that is gathering no moss and is becoming more and more evident over time. And we would not be able in one panel to point to all of the successes that have been created to date. But I do invite you to delve into Chapter 3 of the supplement, where we aimed to touch on all of them. But coming up this year, there are a number of really interesting developments to keep an eye on. The first is a case in France based on the passive nationality, that is the victim's nationality, to establish jurisdiction. As many will know, early on in the conflict, cases like that often met with legal obstacles because the ones that were brought, such as one in Spain, were based not on the nationality of the victim themselves, but on a family member, and jurisdictional challenges brought those cases to a halt. However, a case filed by father and son, Mazen and Patrick Daba, who are Franco-Syrian nationals, regarding their arrest and detention by Syrian Air Force intelligence agents in November 2013, has had a more positive outcome and resulted in the indictment of Ali Mamlouch, Jamil Hassan, and Abdel Salam Mahmoud, who are 3 senior officials, by the Paris Criminal Court. And this is very likely to proceed as a trial in absentia later this year. France has been also very active last year in issuing arrest warrants in 2 other proceedings, including against President al-Assad. And these are also likely to result in trials in absentia in the future. So these will be very critically important proceedings, which vital evidence will be presented and ones to watch. Another notable development is that last year, US officials announced that they are also building a case against Jamil Hassan and Ali Mamlouk, among others, for the arbitrary detention and killing of Syrian American aid worker Leila Shweikhani, which will be the first time a criminal case goes forward in respect of regime perpetrators in the US. So that's another important development coming up in 2024. Next, and I said I would return to it, a corporate criminal accountability case against Lafarge, a cement company that was found to have been implicated in making payments to Islamic State in order to be able to continue its operations in Raqqa during the conflict. This case has a protracted history in both the French courts and now US courts, where initially a complaint was filed on behalf of 11 Syrian workers who alleged they suffered harm as a result of Lafarge's payments to IS to continue its operations. A group of Yazidi victims subsequently sought to join the proceedings, alleging complicity in crimes against humanity perpetrated against them in Raqqa in 2014. The defense challenged these charges and they were initially struck down on appeal. However, most recently, in fact, just last week, so this is not in the supplement, but when we do an update, it will be, the investigating chamber reversed the annulment of the crimes against humanity portion of the case. So that is also likely to proceed this year. And at the same time, Lafarge paid a record-breaking fine of $778 million in the US for supporting terrorism. This was based on the same payments, some of which were routed through New York State. And here is another great example of very creative and determined lawyering in bringing cases on the foot of this, because it has now been announced that some 427 Yazidi victims have filed suit for damages in the state of New York. So that will be another very interesting process to watch this year. A fourth very creative example comes from Australia, where a group of 5 Yazidi women who were enslaved and subjected to sexual violence by an Australian IS member who is now deceased and therefore will not face trial, sought to benefit from an administrative compensation scheme, but were rejected by the tribunal and then by the Court of Appeal and then by the High Court of Australia. But lawyers representing this group have vowed to take a communication to the Committee Against Torture for a ruling on Australia's obligations under the Convention Against Torture in this regard, so we may not have heard the end of this process. And finally, as many of you know, we will await the outcome in the long-running trial against Ala M concerning a doctor who served in military intelligence. He stands accused of torture and sexual violence in several regime-controlled places of detention in Homs, including charges of deprivation of reproductive capacity in relation to an alleged incident in which the accused doused the genitals of an adolescent boy with alcohol and set him on fire. So all of these are examples of how that stone of justice continues to turn despite the major impunity that reigns in Syria and the lack of international mechanisms to take the justice project forward. We do, of course, still have major lacunae in order to truly advance accountability. We do sometimes see examples of cases that go forward missing the opportunity to charge conflict-related sexual violence for what it is. A series of cases in Europe and the US against female foreign terrorist fighters have often brought to the surface facts which show that mothers who brought children to Syria failed in their duty or actively participated in exposing boys to being used as child soldiers and to girls to forced marriages with members of IS, but rarely has this been charged as such. However, prosecutors are beginning to become alive to that issue. And in January of last year, we did see the first conviction of a Swedish woman, Camilla Olofsson, for trafficking and aiding abetting the aggravated rape of her own daughter after she was forcibly married to an IS fighter in Syria. But it's also sadly true that in these extraterritorial and universal jurisdiction cases, we will always see a self-selecting form of justice based on the availability of suspects in the states that are willing to exercise jurisdiction to prosecute them, or trials in absentia in some cases. So some are continuing to advocate for the creation of an internationalized court for Syria, and we discuss this in Chapter 3 of the supplement. Such a court would be based on a multilateral treaty in order to bypass the deadlock in the UN Security Council, and it would find its basis in the pooling of jurisdiction of each signatory state. This proposal has received some discussion over the years, notably by Sweden and later by the Netherlands, and in the context of measures that could be taken under the Chemical Weapons Convention. But so far, no serious proposal has been put forward. However, it does continue to be discussed among like-minded states and legal scholars and should remain something at the top of the agenda. It's time for me to wrap up my own remarks. And I'd like to finish just by noting that, of course, the core message of the IP2 supplement is the importance of adhering to the minimum standards to ensure survivor-centered approaches. But very closely related to this is the need to integrate strategies for case building and sharing of materials into the documentation and investigation efforts from very early on in the process. Documenters and investigative bodies should be aware of all of these ongoing processes and be highly networked in order to ensure the collaboration and support necessary in order to be able to bring all of the material that has been gathered to the attention of authorities and enable victims to participate in proceedings as witnesses or in some cases as co-plaintiffs. So there are just a few parts of the supplement I would like to highlight in that regard. I've already mentioned the charts in Chapter 3, breaking down the cases against both regime and IS. And I would note that also besides the supplement, there are good ways to keep tabs on the developments in these cases. For example, the Syria Trials podcast, Trial International's Universal Jurisdiction map, and of course, webinars with the community like these ones. In addition to that, chapters 10, 13, and 14 of the supplement discuss various types of evidence of CRSV in the Syrian context and how the gathered materials, whether it's testimony, documents, expert medical reports, physical evidence, or digital or open source materials, should be managed, stored, analyzed, shared, and relied upon in order to assist law enforcement actors to deliver justice to victims and survivors. And here, the guidance in these chapters is really focused on the types of evidence that can be gathered and preserved for the future or relied on in the kinds of cases I've referred to today, that is extraterritorial or universal jurisdiction proceedings, given the fact that there is very little hope for domestic or international level accountability. So these chapters give advice on issues relevant to case building aimed at other domestic and international jurisdictions, showcasing examples from cases supported by materials gathered in Syria to date. And some of the key topics addressed are avoiding duplication and filling gaps, working with the appropriate repositories for evidence, such as the IIIM, gathering an array of types of evidence beyond survivor testimony, and having policies and systems for storing and sharing evidence. Some of the lessons learned on the importance of analysis are included, including contextualizing CRSV in relation to other crimes, considering linkage to perpetrators entities and other individuals, and relying on analytical processes and tools, as well as addressing gaps and weaknesses in gathered information while these documentation and investigation processes are still ongoing. All very complex work in which I know many members of our audience are engaged. So I'm looking forward to moving into the discussion, which I am now going to do. Thank you very much for listening to me. And I just have to open the Q&A. I don't see any questions in the Q&A, so I will now turn to the audience to see if we have any speakers. Could I please ask anyone who is called upon to, first of all, respond to the prompt to unmute yourself, as Christy mentioned, and a reminder to please also mention your name and affiliation as you introduce your remarks. So I have first Dr. Aswat, the CEO of LDHR. Are we able to? Dr. Aswad, I think you're unmuted. No, he is not unmuted, in fact. Sorry, I was going to ask a question to the booth, but maybe it's a question to our program team. Are we able to unmute Dr. Aswad? Or send him the signal? Okay, while we work on that, I will just collect some more questions. I have Louis Cano will be our second intervention, and then Erin Gallagher will be our third intervention. So coming back to Dr. Aswat.
Sorry for interfering here. Louis, if you can unmute your mic, you have the permission to talk. Should be okay now.
ألو مساء الخير. الله يخليكم. آسف للتأخير.
Hello, good evening. I'm Luis Nakos Ayub. I am from Hamra, a human rights organization from Iraq. What I want to ask about the situation, as the colleague from Syria mentioned, they are no different from other situation in the Arab East. So most of the laws are similar in different countries, and in general, they don't achieve or serve justice for the families of victims or victims themselves if they remained alive. In Iraq, the crimes that were perpetrated by the terrorist group of ISIS, we have a huge amount of those crimes that continue to be either in the halls of the courts that need a lot of tools to address these courts. For example, in the Iraqi laws, we don't have laws to address that, but the law that we are using in Iraq is the counterterrorism law, which does not serve justice in terms of the description of so many of the crimes that are perpetrated. So we need a specific law to criminalize or to punish those people who perpetrated physical violence and enslavement and crimes against humanity that are very severe, especially, for example, the crimes that were perpetrated in Nineveh against Yazidis, Christians, and other minorities in the region. Those crimes, until today, we have concern, so until now, that the government doesn't have a strong willingness to serve justice. The mechanisms available are very poor. We need to have a special tribunal to hold those perpetrators accountable and a specific law to address this problem. And this is going against so many political willingness of parties in Iraq. Maybe so many of those parties are afraid to be held accountable because at some point they were part of those crimes or that they contributed to some of the points that facilitated perpetrating these crimes by those perpetrators on purpose or unintentionally. So this is the situation in Iraq. My question is, how can those victims have justice served or have their rights redressed in Syria or in Iraq in light of the weakness of international institutions? Although they sacrificed a lot, and those international institutions built the capability of civil society organizations and some governments. But in Iraq, in specific, for example, we have the International Committee that is responsible for the collection of data. I believe we are in a situation that is problematic for the data collection in Iraq. Now, by the request of the Iraqi government, there is a request by the Iraqi government to stop collecting data of this committee and to stop the work of this entity. Now, with so many friends who are working in human rights organizations and in alliances for the compensation for families in Iraq, with the support of international organizations, including the German GIZ and other organizations, we have concerns and we have lack of trust. Despite all of the circles that brought us together with some governmental entities and Iraqi judges, we have concerns about this important issue and under what hands is it put under the political quarrel that we are having in Iraq. So such issues cannot be put under control of governmental bodies or certain hands if we don't have international guarantees to make sure that such efforts that have lasted for over a year and a half and there have been important and dangerous information collected in that track. So the question is, how can the international community and international institutions support this work, and what recommendation they can make to the Iraqi government, and what party should be the one that can provide guarantees for this issue, which or this file that includes data and information that can be used or abused, and that, if served well, it can bring stability to the society, especially that it caused thousands of families to flee from the area. For example, in Germany, we have more than 1,000 families of the Yazidis who survived that period. And there are other countries whose host other families, Christian families, and from other minorities. So this is the question. How can we have a trust in an entity, and what entity or what party can give us assurances that the data will be safe until there is a national Iraqi vision that is serious to serve justice at the national level and to have national mechanisms to support this justice, including courts and other points. Thank you, and sorry for taking too much time of your time.
Thank you very much for the thoughtful comment. I think we'll collect a few. Erin, would you like to take the floor?
Can you hear me? First off, just congratulations on a really excellent supplemental to the IP. It's a wonderful resource. I've already been looking at it, and yeah, thanks for Synergy and LDHR and all of your hard work for a really comprehensive resource. Two quick questions. I'm taking us on a slightly different track, and this could be for Dr. Muhammad or Siba. But you talked about creating a safe space in order, especially was for men to be able to come forward and talk. And if you could give us a little more of a description of how you create that safe space, I think emotionally, not just physically, what that looks like, I think for all the documenters in the audience. And then secondly, Jumana, you mentioned about the impact that the Canadian and Dutch submission to the ICJ may have had on the Syrian courts. And I was wondering, I know it might be speculation, but if why do you think there was some influence there, and what might you expect as the ICJ case and hearings come up in the future? Thank you.
Thank you very much, Erin. I think that Dr. Aswad might be busy trying to sign out and re-sign in so that he can ask his question, but I'll take one more for the floor, and then we'll come to the questions in the Q&A in the next round. So I have Tarek Alamar.
الله يعطيكم العافية. السلام عليكم.
Thank you very much. Hello.
حياك الله. أنا بس في عندي 3 نقاط بدي أحكي
I
فيهم.
have 3 points. So, for example, we have seen very important points, and we need to focus on which come under torture and sexual violence. For example, somebody with his wife, and they have a son. They were going from regime-held areas to liberated areas. At one of the checkpoints, his wife was very beautiful, so they called the officer at the checkpoint, the agents. They told him, "We found you a good woman." So the officer came and he told the man, "You will go with your son and leave your wife here. Otherwise, we are going to rape her in front of you. So negotiate with your wife and take the decision that you want." So here the woman, under the pressure, told him, "We either die together or not." So then they negotiated. They said, "Okay, go with the son, and I will be here." So the officer took the woman, and then he left her until as if she was divorced. So he waited for a period, the period of divorce, and then he made a legal marriage contract with her. So I believe that this is, despite the legal facade that he followed, I believe this is illegal and illegitimate practice. So the second point, after the ruling gang in Syria signed the CAT agreement, that I believe that any case that is under the Syrian law can be prosecuted under the Syrian law, I believe. The third point, based on what Mr. Lewis said, I have a wish. If we can make courts in the liberated areas under international sponsorship, using international expertise to have trials against any perpetrator in this field, whether we're talking about perpetrators from the regime or from other parties. Thank you very much. Those are the points that I wanted to share with you.
Thank you very much. I'll give the floor to Dr. Mohammed and then to Ms. Siba to respond to the question on safe spaces.
تمام شكرا ستيفاني
Thank you, Stephanie. Thank you, Aaron, for your question. I will talk about the safe space, not the physical space, but the emotional space, which relies largely on the training and the qualification of the documenter who is dealing with the survivor. When the survivor feels that he is in a space where he can say anything with complete confidentiality, after all of the limits of confidentiality and the maintenance or the preservation of data is provided, so the survivor is given this space to tell the story that they have. In addition to that, given control to the survivor and enabling it enables them during the interview, they enables them to feel that they are the ones controlling the interview and they are not speaking under any pressure, any kind of a pressure, and they want to speak that. I will quote one of the sentences one of the survivors said at the end of the interview of documentation. He said, I felt that there is a hole that was open in my chest, and I said things that I never thought I will be saying to anyone. So this, of course, relies on the training and the quality or the qualification that documenter has acquired in order to reach that point.
Ms. Siba?
شكرا كثير أكيد بشارك الأستاذ محمد.
Thank you, and I would like to. I agree with Dr. Muhammad that when the survivor knows that that the data they are giving will be confidential. For example, I will give here another example from my experience when a female documenter is documenting for a male survivor. I have met a lot of people who have the stigma, so they don't want to share or they don't like to share any of the violations that they underwent in detention. As Dr. Muhammad said, that when they believe that in the qualifications of the documenter, and this is the first point for us as survivors, it's very important for us to talk about what we have gone through and to go through the process of documentation. There are some male survivors who don't want to document with a female documenter. But when we tell them that we as women survivors, despite of the violations that we have undergone in detention, we are sharing our experiences and we are raising our voices for the entire world to know what are the practices that are taking place in a prison. So the survivor, the male survivor, he would say, if women are so courageous to talk about their the violations they have undergone, so they start to speak openly without that shame that they hold. So that's why once again, this is another perspective where a male survivor is speaking to a female documenter. Thank you.
Thank you. And I come to Jumana.
Yes, thank you, Stephanie. So quickly, بالنسبة للعدل الدولية
So, in terms of the International Court of Justice and the preemptive measures that were taken by the Syrian regime, I believe that the Syrian regime is concerned about this submission, although they didn't appear in the, they didn't show that. And the regime is not going to implement the temporary or interim measures, although they are very weak and they were issued uh, uh, in a weak language, but we don't know where would that lead. However, we in the Syrian society community, we will work or we will do our best for this trial to achieve genuine results in terms of serving justice. I believe this is one of the duties that we have. Very quickly as well, to answer the question of Mr. Tariq, in terms of this detention of the lady at the checkpoint and then getting married to her later, for sure, this is a coerced sexual violence, or we can say it's rape, and especially for in terms of sexual violations, the definition of coercion is very broad, and there is no question in this case that this is sexual violence against her. And maybe Stephanie can have another addition or clarification about this issue. Thank you.
I certainly agree. And I will just come back to the comments from Luis in Iraq. Thank you very much for your exposition on the situation in Iraq, which is really relevant to everything we're talking about today. I mentioned in my remarks some of the lacunae that we see in justice, and certainly Iraq is a microcosm of some of those lacunae, because so many of the IS perpetrators are held in detention in Iraq. So many of the victims of sexual enslavement and other crimes, and many, many crimes that were also perpetrated against children of sexual nature and not, on the territory of Iraq, are Iraqi citizens and are now back in Iraq. And it's really incumbent upon Iraq to address this. I think that we don't have time, unfortunately, to unpack what should really be a multi-pronged strategy working at various levels to support Iraqi authorities to address justice challenges. But I think what is really clear is that the presence of documentation and investigation initiatives, whether they are by civil society or survivors themselves, or whether they are solutions brought by the Security Council or at the UN level, does not solve the quest for justice by victims if there is no viable recourse to a court or tribunal. And that tension we see across the whole Syria conflict and conflict with IS, and remains a major one to be resolved. I'm sorry for that slightly dissatisfactory answer. We're out of time, but we propose to take another round of questions. This time I will go to the Q&A before we wrap up. And of course, any of you who are not available to stay with us, I apologize, but thank you for your attendance. I'm coming now to the chat, and I'm going to read the questions in English so that they can be interpreted for our panel members who speak Arabic. We have a question from Justin Het. Thank you so much for the informative presentations. What do you see as the main challenges for providing adequate support to Syrian witnesses participating in legal proceedings? And based on your research, how might these challenges be addressed? We then have a second question from Dr. Colleen Keevlahan, who is Medical Director here at Synergy for Justice. Thank you, Colleen, for joining us. When you consider your vast experience over the past decade, what 3 things would you say are most important for other countries currently in conflict to learn and implement? And finally, we have Dina Al-Shafi, who, if I'm recognizing the name correctly, is an expert on the Synergy roster of experts who supports our training programs. Thank you for being with us, Dina. Very interesting webinar, interesting research, work on sexual male violence, always a topic with lack of information. I am not legal, however, it was very easily informative for a non-legal person. How does psychological evidence without physical evidence help in making a stronger case for documentation? How does the legal part see it in case of consistency for the survivor's accountability? Jemana, if I may, could I come to you first to respond to any or all of those questions that you would like to? Is that all right?
It's okay. Yeah, it's all right. Thank you. So, بالنسبة التحديات اللي بتواجه في أعمال التقاضي، أعتقد إنه كمان التحديات.
In terms of the litigation, I believe we have a huge challenges for litigation based on the conditions and based on the place where the prosecution will take place. So if we focus on Europe and the cases that are filed in Europe, I believe the first challenge is the presence of the perpetrators, whether we're talking about regime perpetrators or perpetrators from other actors, to be on the territories. Because for witnesses, even if they fled regime-held areas, so it doesn't mean that their family members are not still living in that area, and they have they are sometimes living under direct threat of revenge from them. And sometimes there is lack of support, especially psychosocial support. So for those who are present in Europe, sometimes this is an obstacle because they didn't receive that kind of support. There are other obstacles or other factors, and those factors need a lot of discussion. Maybe the time here will not help us.
Thank you. And I give the floor to Dr. Mohammed.
شكرا ستيفاني.
Thank you, Stephanie. I will answer Colleen's question. Thank you, Colleen. Your question is very important. I believe the most important 3 things that we need to take into consideration. First, we need to learn from the experience of each other. The experience of the Syrian conflict should not be repeated in other countries that are witnessing conflicts. And the experience that we have learned in the past 10 years should be communicated to those countries in order not to repeat the invention of the wheel every time, so to speak. So this requires training the doctors and the practitioners to deal with survivors and to have the appropriate experience to document violations. This leads us to the third important point, which is to start early on documenting the violations. This did not happen in Syria. We started documenting the cases after years of the violations or the conflict, and this led to the disappearance of so many of the physical evidence that we have. I will comment also on the comments of Justin. Indeed, most of the Syrians
يكونوا شهود أو يكونوا جزء من الإجراءات القانونية
did not come forward to be part of these proceedings for several factors. Most importantly, and this is something that we have addressed in the research that we've made, first, the lack of belief in justice. So many survivors don't think that if they participated in the proceedings, justice will be served. And that's what Stephanie and Jomana talked about. It is very important to notice those cases because the amount of cases and those that are trying to serve or redress survivors, we need to shed light on those cases to tell people that there are venues for justice that are being sought. The other factor is that we have people who are still in Syria and they are afraid or concerned that the same violations might be perpetrated against them again or against their family members. The third point is some people are not coming forward because they are afraid the society might punish them. The final point, which is also important, so many survivors after documentation, they say that they didn't know those mechanisms or these venues were available to redress. So the lack of information is another factor.
Thank you very much. I'll add a couple of remarks myself. In response to Justin's question, I think we see a few things emerging in the cases that have happened in Europe and beyond in regard to witnesses and survivors' participation that have been slightly less than positive. Of course, in some of those cases, we have seen pressure on survivors, both in terms of disclosure of their identities and more explicit threats to their safety and security and their family members back in Syria, and that is an issue that requires very grave and immediate attention when it arises. We've also seen issues of interpretation arise in some of the cases, and in particular those cases that have involved survivors who perhaps don't speak Arabic but speak Kurdish or dialects, where there have been difficulties in the survivors understanding the court proceedings and also in them being understood during the court proceedings, which is certainly something not unique to cases from the Arab world and is often seen in universal jurisdiction proceedings worldwide, but also requires both advanced thought and response from the court when it arises. And finally, I would say that in some cases, we also see worrying signs of stigma and misconceptions and harmful attitudes from the bench or from other parties in the proceedings. And it's by no means the case that just because a proceeding is taking place in Europe, that it's free from these issues of stigma arising in proceedings, which is one of the reasons why Synergy for Justice has developed a stigma justice toolkit, which it will be piloting this year, and Christy will say more about that in a moment. And then Dinah, very briefly in response to your question, there have been many legal precedents developed both at the international level and also at the national level in regard to war crimes cases where there is presence of a narrative account from a witness or psychological evidence available directly from the witness or a healthcare provider, but no actual physical evidence of sexual violence that has allowed that material to be introduced. And in general, there is a principle at the international level of not requiring physical evidence of penetration or corroboration of evidence from survivors of sexual violence, which we are increasingly seeing embedded into national practice. But that is something that still requires further dissemination and entrenching into national practice. But the precedents evidence are there and just need to be disseminated, discussed, and trained on a lot more. Thank you very much to everyone. I do apologize to those that we didn't get to who raised their hands or typed into the chat. We are going to try to answer everyone in writing in the remaining time. Please feel free to be in touch with us afterwards if you have burning questions that were not answered. And I will now hand the floor back to Christy to wrap up. Thank you.
Awesome. Thank you, Stephanie. And huge thank you to all of our panelists, co-authors, contributors, and to all of the participants as well for joining us today and for staying extra long. As we all know very well, it's such a difficult topic to work on, and it's often so disappointing and disheartening when we don't see the progress that we want to see as fast as it is. But I know we're always heartened and feel better after we see this, this kind of group of people and the commitment that they have. I'm always inspired by all of you, and I thank you all for the work that you're doing. A couple of quick notes before we end. In the chat there, you should have seen from the beginning, we had the links to the Syria Supplement itself. Mira has also added in a link to the Synergy research article. It's actually the press release about the article, which also contains the link to the eClinical article as well on male sexual violence in Syria. You can also see a link in the chat to sign up for our newsletter. I promise it's not a bunch of spam newsletter. We typically email about once, maximum twice a month. We try to be informative about what's going on in the field. And also to share news about new webinars that we have coming up, following up on what Steph mentioned about the Stigma Toolkit. Next month in February, we will be putting together a webinar on that. So we'll be publicizing that on social media, but also if you sign up for the newsletter, you'll automatically get notification of that. And then in March, we'll be doing another webinar on focusing specifically on the male sexual violence research that we've referenced a few times that Synergy and LDHR undertook with the University of Galway. One last thing, as Steph mentioned, if you have questions or comments, anything that you want to follow up on, you can email us at info@synergyforjustice.org. I promise it's not a black hole of an email. I actually monitor that email box. So if I can't answer your question, I will forward it to whoever can answer it. And we do consider the Syria Supplement to be a living document. So if you see problems with it, improvements that can be made, ways it can be expanded in the future, please do always feel free to forward those messages also to info@. We'll take a look at them. I'll share them here with the co-authors and with our experts, and we'll see what we can do to integrate new ideas and ideas as they come along. So with that, I think did I forget to thank our amazing interpreters? They always do such an incredible job. So thank you, Omar and Donna. And thank you to the Synergy team as well for organizing this on the back end. It's a lot of work, we all know. So thank you for making it so smooth. Really appreciate everyone's attention and efforts this afternoon and for all that you're doing to support the survivors of sexual violence in Syria. Thank you, everyone.